You found the podcast, Go Beyond the Brief, where we take a deep dive into the societal currents shaping our lives. Together, we'll explore the often unseen forces at play. We'll examine the research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society,
You're walking
this is
past a
the
local
place.
bank on a Tuesday afternoon.
Right, just a normal day.
Exactly. The sun is shining, you've got your smartphone in your pocket, and you are completely oblivious to the fact that, 20 feet away, inside the lobby, an armed robbery is unfolding.
You're just minding your own business.
Yeah, you keep walking, maybe grab a coffee and head home. But hours later, simply because you had a few everyday apps running silently in the background of your phone, you've become a data point in a federal criminal investigation.
It's honestly terrifying when you think about it.
It is. Your digital avatar has just been scooped up, analyzed, and categorized by detectives that you will literally never meet.
And the really chilling reality of that scenario is that it requires absolutely zero suspicion on the part of the police.
Right.
Like, you are entirely innocent, you're doing nothing wrong. Yet, the normal, everyday background functioning of modern technology has essentially drafted you into a virtual dragnet.
Yeah, because law enforcement didn't follow you, right? They didn't single you out.
No, not at all. They just cast this massive invisible net over an entire geographic area, and they haul in everyone's digital life to just, sift through the catch.
Okay, let's unpack this, because that invisible net and the massive legal earthquake it caused is our focus today.
I am so ready for this one.
Welcome to this custom-tailored deep dive. We are unpacking a massive collision between 21st century surveillance technology and the 18th century Fourth Amendment.
Specifically, zooming in on the groundbreaking June 2026 Supreme Court case, Chatrie v. United States.
Yes, and we are working through a pretty dense stack of sources today. We've got detailed legal commentary on geofence warrants, the underlying tech white papers on location tracking, and of course the actual Supreme Court opinions from just a few weeks ago.
Right, so the majority opinion, the concurrences, and some really fierce dissents.
Definitely. Because we are looking at a fundamental rewiring of how the legal system understands privacy.
Yeah, and to even begin to grasp the philosophical divide at the Supreme Court, we really have to start with the mechanics.
The tech itself.
Exactly. I mean, we can't debate the constitutionality of a geofence warrant without understanding the really granular step-by-step technological process that allows police to essentially rewind time and watch a crime happen on a digital map.
Okay, so let's anchor this in the physical reality of what happened before we get into the servers and the algorithms.
Good idea. Set the scene.
May 20, 2019, Midlothian, Virginia. At 4:50 p.m., a man walks into a local credit union.
Right.
He hands the teller a handwritten note demanding $100,000, claiming he has, quote, boys on the lookout.
Which is a bold claim.
Very. Then he pulls a firearm, forces the manager to open the vault, and just walks out with $195,000.
So this is a terrifying, highly physical, very traditional crime.
Exactly. And the police hit a brick wall almost immediately. The suspect fled on foot.
No license plate, no getaway car.
Right. The only useful piece of physical evidence they have is security footage showing the suspect lingering near a church next door right before the robbery, and he's holding a cell phone to his ear.
And that cell phone detail is the entire pivot point for modern law enforcement.
Because normally they'd need to know who he is first, right?
Yeah, traditionally, detectives would need a suspect before they could really do anything. They'd lean on informants, pull fingerprints, and then once they had a name, they'd go to a judge for a warrant to search that specific person's property.
But in this case, the Virginia police inverted the entire investigative model.
They absolutely did. They didn't have a suspect. So they turned to Google's Sensor Vault.
Which is what, exactly? Just a giant database.
Pretty much. It's a massive, centralized database storing the location history of hundreds of millions of devices.
Wow.
Yeah. So the police applied for a geofence warrant, basically asking a magistrate for permission to search a physical geographic space rather than a specific person.
I really want to dissect exactly how they executed this search because the sources break this geofence warrant down into a highly formalized three-step process.
It's not just the police asking Google for a name, right?
Exactly. It's a filtration system. So step one starts with the geographic boundary. The police draw a 150-meter radius around the credit union.
Okay.
And they compel Google to hand over data for every single device that appeared inside that circle during a specific 1-hour window.
So 30 minutes before the robbery and 30 minutes after.
Right. And Google is required to provide this as anonymized data.
Which is key. The output of step 1 is essentially just a spreadsheet of digital ghosts.
Digital ghosts. I like that phrasing.
Yeah, Google provides the police with 19 anonymized devices, 19 random strings of numbers representing 19 actual human beings who just happen to be inside that 150-meter circle.
And the police have no idea who these people are.
None. They just have timestamps and coordinates.
But those coordinates are incredibly precise, right? Like if the police are looking at a digital map of those 19 dots, they know exactly what the physical suspect was doing at specific times.
Right, because the security camera showed the suspect at the corner of the church at 4:48 p.m.
So they filter those 19 dots. They're looking for the one digital ghost that was standing at those exact coordinates at that exact minute, and then moved into the credit union lobby at 4:50 p.m.
Which perfectly triggers step 2.
Right. What happens in step 2?
So the police find patterns in the anonymous data that match the physical crime, but they need to eliminate the collateral data, the innocent bystanders.
The people just walking by.
Exactly. So in step 2, the detectives go back to Google with a narrowed list. They select 9 of those 19 anonymous devices and demand a broader data set.
They want more info on those 9.
Yeah, they ask to see the movements of those 9 devices for a full 2 hours. And crucially, they want the data for outside the original 150-meter geofence.
Wait, really? This is where the dragnet expands significantly then?
Hugely. The police are essentially asking, well, where did these 9 ghosts come from before they arrived at the bank, and where did they run to after?
They want to see the approach and the getaway.
Exactly. By analyzing these extended digital tracks, they can eliminate the people who don't fit the suspect's profile.
Ah, so if one anonymous dot drives off at 60 miles an hour down the highway, but they know the suspect fled on foot.
That dot is eliminated. They're innocent.
Okay, I see. So only after filtering the data based on those extended behavioral patterns do the police move to step 3.
Yes, the final step. They narrow the list of 9 down to just 3 devices that perfectly mirror the suspect's behavior.
And for those final 3, this is where the police compel Google to strip away the anonymity.
They demand the names, the email addresses, the subscriber information, everything.
And one of those 3 names is Okello Chatrie.
Right. His digital footprint placed him near the church, inside the bank during the robbery, and then fleeing toward a nearby residential area immediately afterward.
You know, the reliance on quote-unquote anonymized data in steps 1 and 2 is fascinating to me because it completely changes the nature of anonymity.
How do you mean?
Well, anonymity usually implies protection. You know, we think of it as a shield against government intrusion. But here, the police are essentially weaponizing that anonymity.
Oh, for sure?
They are using the anonymized dots to surveil behavior, track movements, and eliminate suspects before they even know who they're looking at.
Well, the term anonymized is actually actively misleading in the context of location tracking anyway.
Really? Why is that?
Because human movement is inherently unique. The data points might just be random numbers on a spreadsheet, but if a supposedly anonymous dot sleeps at a specific residential address every night,
Right.
and then drives to a specific corporate office every morning and drops a device off at a specific elementary school at 8:00 a.m.
I mean, the identity of that person is blatantly obvious to anyone looking at the data.
Exactly. The anonymity is merely a temporary mask that the police can just pull off whenever the behavioral pattern gives them the justification they need.
It fundamentally changes the physics of a police investigation. Like to physically track 19 people for an hour, monitor their movements, watch where they go after they leave a location.
That would take dozens of undercover officers.
Multiple vehicles, air support, massive coordination. It's economically and practically impossible in the real world.
Yeah, but here, a single detective sitting at a computer can execute a retroactive surveillance operation on dozens of people simultaneously.
It's like releasing a radioactive isotope into a city's water supply and then using a scanner to trace everywhere the water went just to find the one person who took a drink at 4:50 p.m.
That is a great analogy. And the collateral tracking of innocent people is just immense, all just to locate the target.
And that collateral tracking forces a massive constitutional question, because the government argued throughout this litigation that because the data in steps 1 and 2 was technically anonymous, no Fourth Amendment search had even occurred yet.
Right. They argued that grabbing the location data of innocent bystanders doesn't violate their rights if their names aren't attached to the file.
Which means this entire case hinges on determining exactly when the constitutional tripwire is crossed in a digital environment.
Exactly. Which brings us directly into the friction between the text of the Fourth Amendment and the reality of 21st century infrastructure.
So the Constitution protects against unreasonable searches and seizures. But for centuries, that was entirely tied to physical trespass, right?
Yeah, if a constable kicked down your door, that was a search. If they didn't touch your property, it wasn't.
But technology completely shattered that framework. I mean, you can't physically trespass on a phone call.
And the Supreme Court recognized that physical limitation back in 1967 with the Katz case, Katz v. United States.
Right. Refresh my memory on cats.
So the FBI attached a listening device to the outside of a public glass telephone booth to record a gambling suspect.
Okay.
The government argued it wasn't a search because they never broke the plane of the booth. They didn't physically trespass.
But the Supreme Court rejected that.
Right. They famously declared that the Fourth Amendment protects people, not places. Katz created the modern framework that a search occurs whenever the government violates a person's reasonable expectation of privacy.
But the problem with that Katz test is that it spawned the third-party doctrine in the 1970s.
Yes, through cases like Miller and Smith.
Right. The court ruled that if you voluntarily hand information over to a third party, like giving your financial records to a bank, or dialing a phone number that routes through a telecom company, you forfeit your expectation of privacy.
Because you took the risk of sharing it. So the government can just subpoena the company to get it without triggering the Fourth Amendment.
And the third-party doctrine worked reasonably well in an analog world, right, where sharing info was a distinct, conscious choice. Writing a check and handing it to a bank teller is a deliberate act of disclosure.
But modern smartphones don't operate on deliberate disclosure. They operate on continuous silent telemetry.
Yeah, and that exact tension is what forced the Supreme Court to intervene in 2018 with Carpenter v. United States.
Oh, Carpenter. That was a massive case. In that one, police grabbed 7 days of cell site location information, CSLI, from wireless carriers to track a robbery suspect.
And the government leaned hard on the third-party doctrine there, didn't they?
Very hard. They argued the suspect voluntarily shared his location with Sprint and T-Mobile just by having his phone turned on.
But the Carpenter ruling was a massive shift.
It was. The court ruled that cell phones have become such a pervasive, insistent part of daily life that they're practically a feature of human anatomy.
Wow, human anatomy, that's strong wording.
Yeah, they determined that people absolutely have a reasonable expectation of privacy in the whole of their physical movements.
So the court effectively carved out an exception to the third-party doctrine there, stating that grabbing 7 days of cell tower pings was so invasive that it required a warrant, regardless of the data being held by a third-party telecom company.
Exactly. Now, fast forward back to our current case, Chatrie. The government's strategy was to heavily distinguish Google's location history from the cell tower data in Carpenter.
They built their defense of the geofence on two major arguments, right? Duration and choice.
Yep. First, they argued that a 2-hour geofence sweep is incredibly short-term compared to the 7 days of tracking in Carpenter.
They claimed 2 hours doesn't reveal the whole of a person's physical movements, so it shouldn't trigger the same constitutional alarms.
The prosecution really relied on the idea that a brief snapshot of location data doesn't expose the intimate, deep-seated realities of a person's life.
They likened it to a police officer simply tailing a suspect's car down a public street for a few miles, something that has never required a warrant.
Right. And their second argument leaned heavily on the mechanics of Google's software itself.
Oh, because cell tower pings, like in Carpenter, are unavoidable. If your phone is on, it talks to the tower.
Exactly. But the government argued that Google's location history is an entirely optional opt-in feature, like the user actively clicked an agree button to turn it on.
So their stance was that Chatrie voluntarily chose to let Google track him, therefore the third-party doctrine should apply, and the data loses its constitutional protection.
To dismantle that argument, the defense had to expose the sheer mechanical difference between the cell tower data of 2018 and the Google Sensor Vault data of 2019.
The sources make this clear. Comparing the two is like comparing a magnifying glass to an electron microscope.
Totally. CSLI, the cell tower data, is geographically broad. It might place a device within a wedge-shaped sector covering anywhere from 1/8 of a mile to 4 square miles.
That's a huge area.
And it logs that data intermittently. maybe 100 times a day when the phone receives a call or a text.
But here's where it gets really interesting. Google's location history is terrifyingly precise by comparison. The sources show that Google aggregates data from GPS satellites, Wi-Fi network MAC addresses, and Bluetooth beacons.
It doesn't put you in a 4-square-mile sector. It pinpoints you within 20 meters.
20 meters. And it doesn't log your location intermittently, it logs it constantly on average every 2 minutes. That is over 700 times a day.
And the most staggering technical difference is the z-axis.
The elevation.
Yes. Location history logs elevation. CSLI can tell a detective that a suspect was on a specific block in Manhattan. But location history can tell the detective if the suspect went to a free clinic on the first floor of the building or a high-end psychiatrist's office on the 12th floor.
That is, the granular intimacy of that data completely destroys the government's argument that a short-term 2-hour sweep doesn't reveal private information.
Exactly.
If that geofence captures you inside an abortion clinic, an infectious disease center, or at a political protest, it doesn't matter if you were only tracked for 2 hours. The nature of the location itself exposes the most intimate details of your life.
A 2-hour slice of sensor vault data is infinitely more revealing than a week of broad cell tower pings.
And addressing the government's argument about choice requires looking at the realities of the digital ecosystem today.
Yeah, the defense argued that turning on location history is not a meaningful voluntary choice in the traditional sense.
Because Android devices aggressively prompt users to enable the feature, right? When setting up the phone, opening maps, using basic functions.
And the prompts explicitly warn users that their device will not, quote, work correctly unless they enable it.
You are buying a $1,000 piece of hardware that is practically required to function in modern society. And the manufacturer is basically telling you it will be broken unless you agree to constant meter-level surveillance.
Calling that voluntary really stretches the definition of the word to the breaking point. It's closer to digital extortion. You're bartering your civil liberties just to make your GPS navigation function.
The defense also pointed out the psychological relationship people have with this data. Google packages location history into a consumer-facing feature called Timeline.
Right. Users view this as a personal journal. They use it to remember the name of a restaurant they visited 3 years ago or track their jogging routes.
We think of it as ours, even though it sits on Google's servers. The subjective expectation is that this data is intensely personal and private.
So the Supreme Court was forced to reconcile all of this. The staggering precision of the tech, the illusion of voluntary consent, and the massive collateral sweep of innocent bystanders.
Which brings us to the monumental ruling on June 29, 2026. In a tight 5-4 decision authored by Justice Elena Kagan, the court struck a massive blow against warrantless digital surveillance.
Yeah, Justice Kagan's majority opinion unequivocally declared that the acquisition of Google location history data constitutes a search under the Fourth Amendment, firmly requiring a warrant based on probable cause.
And the court systematically dismantled the government's defense, starting with that duration argument, right?
Yes. The government had leaned on an older 1983 case, United States v. Knotts, where police hid a primitive radio beeper inside a container of chemicals and tracked a suspect's car for a few hours.
Right.
The government argued the geofence was just a digital version of that beeper, too brief to invade privacy.
But Kagan completely rejected that comparison. She pointed out that a radio beeper on a public highway is entirely different from a technology that tracks you inside your home, your doctor's office, and your bedroom with meter-level precision.
Kagan's opinion focused heavily on the mechanics of the Fourth Amendment itself. The Constitution does not offer a grace period for surveillance.
Right. The government can't just say, well, the first few hours of tracking don't count.
Exactly. The court replied that the Fourth Amendment is triggered the moment the threshold of privacy is breached, regardless of how long the government lingers inside that private sphere.
And the opinion used this brilliant physical analogy that really clarifies the concept. The vestibule of a house.
I love this analogy.
Yeah. The court noted that if a police officer kicks open your front door without a warrant, steps into the small entryway, the vestibule, and only sees a completely mundane, boring rug on the floor before leaving, the brevity of the intrusion doesn't matter.
Lack of intimate discoveries doesn't matter.
Exactly. The act of breaching the threshold is the constitutional violation. A search is a search, whether it lasts 2 hours or 2 weeks.
And the court also recognized the inherent unpredictability of surveillance. Law enforcement cannot guarantee they won't uncover deeply private associations during a 2-hour geofence. because they don't know what the data contains until they seize it and analyze it.
Kagan argued that allowing a short-term exception would invite the government to constantly roll the dice, sweeping up data on the assumption that they could always claim the intrusion was too brief to matter.
And the majority opinion really didn't hold back on the existential threat this technology poses. Kagan actually invoked the concept of the virtual panopticon.
The virtual panopticon?
Yeah, the idea that a geofence warrant essentially gives the government a time machine. They can look back into the past, surveil anyone anywhere with perfect retroactive memory, simply by sending a subpoena to a tech company.
And the founders explicitly drafted the Fourth Amendment to prevent the British Crown from executing indiscriminate general searches. So Kagan argued that a geofence is basically the ultimate digitized general warrant.
Now, on the issue of the third-party doctrine, the majority definitively extended the logic of Carpenter.
Right. They said that clicking agree on a Google prompt does not amount to a voluntary waiver of Fourth Amendment rights.
Because the data is generated as a byproduct of participating in modern life.
The court held that individuals do not truly share this comprehensive dossier of their movements with Google in a way that surrenders their constitutional protections.
So the Supreme Court draws a hard line. Pulling this data is a search, and it requires a warrant.
Okay, but analyzing the ruling reveals a massive procedural paradox, and this is a big question. The police in Virginia did get a warrant.
Aye, they did.
They went to a magistrate and got a signature for that three-step geofence process. So if the court says you need a warrant, and the police had a warrant, did Okello Chatrie actually win his case?
Well, this is where the Supreme Court's ruling becomes surgically narrow. The majority only answered the threshold question. Is it a search? Yes.
Okay.
But they explicitly declined to answer whether the specific three-step warrant executed by the Virginia police actually satisfied the constitutional requirements of a warrant.
Wait, they just punted it?
Yep. They vacated the lower court's ruling and remanded the case back to the Fourth Circuit Court of Appeals to essentially untangle the mess of whether the three-step process was actually legal.
Wow, okay. So the majority punted on the mechanics of the warrant itself, but we know exactly how contentious those mechanics are because the concurring justices went out of their way to tear the three-step process apart.
Absolutely. Justice Ketanji Brown Jackson, joined by Justice Sotomayor, wrote a concurrence that aggressively attacks the way police handled steps 2 and 3.
Right. She focuses on the core purpose of a warrant. The Fourth Amendment requires warrants to be issued by a neutral and detached magistrate, and they must particularly describe the place to be searched and the persons or things to be seized.
The magistrate is supposed to be the circuit breaker in the system. They exist to prevent police from executing fishing expeditions.
But Jackson argues that the three-step geofence completely bypasses that circuit breaker. Step 1 was authorized by the magistrate grab the 19 anonymous dots.
But the warrant didn't provide any mathematical or behavioral criteria for how to proceed to step 2. It just broadly authorized the police to, quote, attempt to narrow down the list.
It just handed total discretion over to the detectives.
Yes. And Jackson identifies this as a roving commission. Once the ink was dry on step 1, the police never went back to the judge.
They just sat in their precinct and unilaterally decided which 9 dots to track for a wider 2-hour window. And they unilaterally decided to track those dots far beyond the original 150-meter perimeter authorized by the judge.
And the collateral damage of that unchecked discretion was massive.
The sources highlight a terrifying detail here. When the police tracked those 9 anonymous devices in Step 2, the data followed innocent people into highly sensitive spaces.
Right. Private residences, a local school, a medical facility.
They executed digital surveillance on a school and a hospital without ever demonstrating probable cause to a judge that a suspect was even inside those buildings.
Jackson is warning that anonymized data creates a super dangerous psychological loophole for law enforcement. Because the data lacks a name, the police sort of treat it as fair game for endless manipulation and tracking.
So Jackson implies that a constitutional geofence warrant, if such a thing can even exist, would require the magistrate to hard-code the exact filtering parameters into the warrant itself.
The judge would have to dictate the precise speeds, trajectories, and timestamps required to unmask a device, rather than just letting detectives use their gut instinct.
Okay, so that's Jackson's take. But Justice Neil Gorsuch filed his own concurrence that takes a radically different philosophical approach to the entire case.
Yeah, Gorsuch agrees with the majority that a warrant was required, but he completely rejects the legal test they used to get there.
He has zero interest in the CAT's reasonable expectation of privacy framework.
None at all. He views the CATS test as an unstable, subjective mess. I mean, trying to define what society considers reasonable privacy in an era of constant technological disruption is a fool's errand.
So what's his alternative?
He advocates for a strict, text-based, originalist approach based on property law. The actual text of the Fourth Amendment protects persons, houses, papers, and effects.
Effects, meaning personal property.
Exactly. Gorsuch argues that digital data is legally classified as an effect. It is your personal property.
And he builds this argument by pointing to state-level legislation, right? He cites computer crime laws in Virginia, Texas, Georgia, and others, which explicitly classify digital data as personal property subject to larceny and trespass.
Yes, if someone hacks your computer and deletes your files, they have destroyed your property.
So Gorsuch takes that state-level classification and applies it to the Fourth Amendment. If location history is property, searching it is a trespass.
And that property framework fundamentally alters the relationship between the user and the tech company. Under the privacy framework, the government argues you lost your rights by sharing the data.
But under Gorsuch's property framework, it doesn't matter if you share it. It's like renting a storage unit or handing your keys to a valet.
Exactly. You entrust your physical property to a third party for a specific service, but you don't surrender ownership of it.
So Gorsuch argues you entrust your digital property to Google's servers, but it remains legally yours, and the government cannot rifle through it without a warrant.
It's an incredibly clean, objective way to basically bypass the entire headache of the third-party doctrine. If it's your property, it's protected, period.
So between Kagan's privacy arguments, Jackson's attack on the three-step warrant, and Gorsuch's property framework, it seems like an overwhelming victory for civil liberties.
It does feel that way.
But this was a 5-4 decision. The court was split right down the middle. We have to look closely at the counter-arguments, because the 4 dissenting justices believe the majority just detonated 2 centuries of established law.
Right. And to fully grasp the magnitude of this case, it's essential to analyze the dissents filed by Justices Alito, Thomas, and Barrett.
Real quick before we dive in, I just want to explicitly state to you, the listener, that we are impartially reporting the contents of these dissenting opinions.
Absolutely. We are not taking any sides here. We are simply conveying the ideas in the source material to ensure you get a complete, balanced picture of this massive legal debate.
Exactly. So looking at the dissents, they mount a really fierce defense of the traditional legal order, and they start by attacking the procedural validity of the majority's ruling.
Justice Alito, writing the primary dissent, points out a massive irony in the majority's sweeping privacy declarations.
He argues the entire opinion is effectively advisory because of a legal mechanism called the good faith exception.
Right. So even if the Fourth Circuit decides this specific geofence warrant was hopelessly unconstitutional, Okello Chatrie's conviction is likely going to stand regardless.
The good faith exception is really a pragmatist doctrine. The rule that excludes illegally gathered evidence from a trial exists to deter police misconduct. It's meant to punish bad cops.
But Alito points out that the Virginia detectives in 2019 didn't engage in misconduct. They went to a judge, they laid out their evidence, and the judge signed the warrant.
The police relied on that signature in good faith. Alito argues that you cannot punish law enforcement for a constitutional error made by the magistrate.
Therefore, the evidence won't be suppressed, making the majority's grand pronouncements on digital privacy practically meaningless for the defendant.
Okay, so moving past the procedural argument, the dissenters unleash a blistering defense of the third-party doctrine. Alito rejects the idea that location history is fundamentally different from bank records or dialed phone numbers.
He argues that Chatrie absolutely affirmatively volunteered his data to Google.
Because the prompt to turn on location history isn't a secret. The terms of service explicitly state that Google will use the data for targeted advertising, and that they comply with legal requests from law enforcement.
Alito uses a highly effective analogy here to ground his argument in traditional contract logic. He compares Google to a travel agency.
Okay, let's hear it.
Imagine you hire a bespoke travel agency to plan your vacations. To get the best recommendations, you allow them to track every road trip you take, every hotel you visit, every restaurant you eat at.
And the agency builds a massive, detailed chronicle of your travels in their filing cabinets.
Exactly. If a grand jury subpoenas those files, you have no Fourth Amendment standing to stop them. The files belong to the agency. created as part of a voluntary business transaction.
So Alito views Google's Sensor Vault as exactly the same thing, a corporate ledger generated by a voluntary exchange of services.
He does. And the dissenters also hammer the majority for basically ignoring the context of the physical world.
Right, because the entire geofence was centered on a bank robbery occurring on a public street. Historically, the Supreme Court has consistently held that you have absolutely no expectation of privacy regarding your movements in public thoroughfares.
Anyone sitting on a park bench across from the credit union could have watched the suspect walk up to the church, use his phone, and enter the bank.
If a human being can observe it without a warrant, why is it suddenly a constitutional crisis if a digital sensor records the exact same public movement?
It's a very fair question from the dissent, but their deepest fear is the destabilization of the entire legal system. Alito warns that the majority is recklessly unshackling the Carpenter decision.
Unshackling Carpenter. Because Carpenter was meant to be a narrow exception for 7 days of continuous tracking.
Right. By expanding that exception to cover a mere 2-hour sweep of an optional Google service, the majority has obliterated the boundaries of the Fourth Amendment.
Because if a 2-hour sweep of digital records now requires a warrant, regardless of whether a third party holds the data, the implications for other investigations are just catastrophic.
What happens to financial fraud investigations?
Debit cards are just as indispensable as cell phones, and they generate a minute-by-minute digital paper trail of our lives, logging every purchase, every coffee, every subway swipe.
Does the government now need a warrant to subpoena 3 hours of Venmo transactions because it might reveal a private association?
The dissent is arguing that applying the logic of the physical world to the realities of digital architecture is just a flawed exercise that is stretching the judicial branch beyond its capacity.
By trying to invent new tests and redefine what voluntary means in the digital age, the court is throwing decades of established search and seizure doctrine into complete chaos.
Detectives and lower court judges are left with no clear rules on how to conduct investigations in a world where everything generates a data point.
The dissent ultimately raises a really profound structural question about the separation of powers.
Yeah. If the Supreme Court is bitterly divided 5-4 over how to apply an 18th century amendment to 21st century server architecture, should the court even be the one making these rules?
Or is this a massive failure of the legislative branch? The dissent strongly implies that Congress needs to step up and pass comprehensive digital privacy legislation, rather than forcing 9 justices to play technological catch-up.
It is a profound dilemma. We are relying on analog doctrines to govern a digital reality. The judicial system is moving at the speed of litigation, taking 7 years to resolve the constitutional implications of a single bank robbery, while the technology itself evolves exponentially faster.
Which perfectly sets up the ultimate twist in this whole saga.
Ah, yes, the twist. Because we have spent all this time analyzing the profound legal and philosophical battles fought by the most powerful judges in the country.
But while the judicial branch was spending years agonizing over whether your data belongs to you or to the companies holding it, the entire landscape just shifted underneath them.
Exactly. In July 2025, a full year before the Supreme Court issued this landmark ruling, Google fundamentally changed the architecture of its location tracking.
They updated location history, rebranding it as Timeline.
But the critical shift wasn't in the branding, it was in the storage mechanism. Google stopped storing this granular location data in the cloud on its centralized servers.
Instead, they pushed the storage entirely to the client side. The data is now encrypted and stored locally on the user's individual smartphone.
The implication of that architectural shift is staggering. By moving the data off their servers, Google effectively made themselves immune to geofence warrants.
Yep. If a police department comes to Google today with a 150-meter radius request and a judge's signature, Google's response is simple: we cannot comply.
We no longer possess a centralized database to search. The data only exists in the pockets of the individual users.
It completely short-circuits the entire legal debate. The police can no longer execute a dragnet against a tech company because the net has nothing to catch.
If they want the data now, they have to physically seize the individual phone and break the encryption, which requires traditional, individualized probable cause.
It forces us to ask a deeply uncomfortable question about where power actually resides in modern society.
I mean, we just spent an hour analyzing a massive constitutional battle over civil liberties, the Fourth Amendment, and the limits of government power. But ultimately, were our digital liberties protected by the profound historical interpretations of the United States Supreme Court?
Or were they protected by a software update pushed out by a handful of engineers in Silicon Valley?
If a corporate engineering choice has a more immediate, sweeping, and definitive impact on police surveillance than a landmark ruling from the highest court in the land, who is truly acting as the guardian of our digital privacy, the government or the corporations building the infrastructure of our lives?
It's something you really have to think about.
It's a question that extends far beyond the details of one bank robbery in Virginia. And it's something every one of you listening needs to consider the next time a prompt asks you for permission to track your location. Thank you for joining us on this custom-tailored deep dive.
It's been a wild ride.
Keep questioning the invisible digital threads connecting your life to the law. And remember, until next time, your data is never truly asleep.